Supreme Court's July 11, 2024 judgment includes far-reaching decisions that will significantly alter local government administration in the country. The Supreme Court has affirmed the financial autonomy of Nigeria's 774 local governments. In the unanimous judgment of its 7-member panel on July 11, the Supreme Court unanimously upheld the suit brought by the federal government to strengthen the independence of local governments in the country. A member of the panel, Justice Emmanuel Agim, who delivered the court's lead judgment, held that the local governments across the country should, from July 11, receive their allocations directly from the Accountant General of the Federation. He ruled that it is illegal and unconstitutional for governors to receive and withhold funds allocated to local government areas in their states. He ordered immediate enforcement and compliance with the orders of the court by the state governments and successive governments henceforth. Today we'll be discussing an important part of this judgment, and that is the local government tenure elongation by the Supreme Court. The judgment partly reads, under Section 135, subsection 3 of the Constitution, the tenure of 4 years for the President, provided for by Section 135, subsection 2 thereof, shall be extended for periods not exceeding a period of 6 months at any time by a resolution of the National Assembly if it is not practicable to hold elections. By same token, by a law of a State House of Assembly, the tenure of local government councils can be legally extended for any reason, such as insecurity or war, if it becomes impracticable or impossible for elections into the local government councils to be conducted. The mandate given to an elected local government council is the mandate of the electorate of that local government area. And if the tenure is extended, it is the people's mandate that is extended. If the tenure of a local government council is truncated, as it is the norm now, it is an illegal termination of the electorate's mandate, and it is not to be encouraged but roundly condemned. Honorable Churchill, what is your take on this judgment by the Appeals Court?
Let me also, first of all, congratulate the Appeals Court for...
You are congratulating the Appeals Court for doing their job?
For doing their job very well.
You are congratulating
for doing their job very well. So, in the sense that, you know, so many issues has really happened in, particularly I want to draw it down to Rivers State.
Okay.
So many issues has been lingering. High Court, State High Court putting injunction, another State High Court vacating injunction, this one, this one, do this. First of all, I want to start by saying that Martin Samehule is the House of Assembly Speaker we know. And like the Appeal Court said, that nobody has challenged his jurisdiction as a Speaker. And nobody also has apart from one member that is late among the House of Assembly members, other members are intact as House of Assembly members. But I know too well that some members were suspended by the State House of Assembly. That includes Okojombo and about 4 or 5.
Good boys.
Yes, all of them, that they were suspended. So, and they have not been recalled back as House of Assembly members. I asked a question, I said, can a suspended priest be nominated to be a bishop in a church? Some persons answered the way they understand. But I really looked at it in the area of the House of Assembly of Rivers State, where members were suspended, and without knowing, somebody called them in his parlor and so said somebody should be nominated as a speaker. I know too well that the House of Assembly of Rivers State is organized, and they did their election, and every other members that is among the principal officers were elected the same day, and it was published.
But with that we're talking about
I'm digressing down to that area. Okay. Now, when you look at the judgment of the Supreme Court, that is the Appeals Court of Nigeria, you look at it, one, they said that when it's extended, is the people's mandate that is extended. We know too well that the tenure of the local government, like when I served, it was 3 years. And after, we were still in office when election was conducted. And at the end of our tenure, the day our tenure elapsed, that is the day they were sworn in. Now, in this aspect, election is supposed to have conducted all this while, but it has not been conducted. The judgment says that should in case there is war, there is problem. That is, the war means there is issue, or that the state RISEC.
He said for any reason.
Okay, for any reason.
War or insecurity, but then for any reason comes
for any reason,
it, yes.
And the election did not hold. That means the tenure elongation can only be done by the State House of Assembly. And as it stands now, the State House of Assembly of Rivers State looked at it before this time, knowing that they've written to the governor like twice, like the information I got. I told you that my ears are on ground, like twice or thrice for the elections to be conducted. Even the RISEC wrote to the governor for funds to conduct the election, and they were unable, they were not able to conduct the election. Then the House of Assembly sat and passed a bill for the elongation of the tenure. Sent it to they passed the process, sent it to the governor for the governor to assent. And the governor did not assent it for the period of time according to the Constitution. It was brought back to the House of Assembly according to the section 112 of the Constitution, 112 down of the Constitution, and they followed the process. And finally, the bill was represented by the majority leader of the House, and followed the normal process again, and was passed as veto in the House. It was vetoed in the House as a bill for the elongation of 6 months, following the Nigerian Constitution. Following the Constitution. And again, now, the Supreme Court has reaffirmed it, letting everybody know it is no more now the business of the Legislative House. It is now the business of everybody, both the Supreme Court, the court, and the Legislative Assembly. So I want to urge the House of Assembly, the Rivers State House of Assembly, to do the needful by inaugurating these personalities, the local government chairman, for them to continue. Then, but it shouldn't exceed the period of 6 months. The governor should hasten up.
How do you inaugurate outgone chairman in this instance?
They are not outgone.
And then
they follow the Constitution.
Agree with me that right now caretaker chairman exists in Rivers State.
So far as I'm concerned, I know too well that the law in the Supreme Court judgment never permits anything like caretaker. The law in the Supreme Court judgment never permits anything like caretaker. So whatsoever thing the governor has done with some persons, calling them names, caretaker and that, the only thing I know is that the House of Assembly has elongated the tenure of the local government council chairman as according to the Constitution of the Federal Republic of Nigeria, and according to the ruling of the Apex Court of the Federal Republic of Nigeria.
Is it in the place when you say that the Rivers State House of Assembly should enforce it? It's not in the place of...
No, they are not enforce it. Okay, now let me come to that.
Who will enforce the ruling?
God bless you. Now, it has been vetoed. The Commissioner of Police have heard now, not from the House of Assembly, heard from the Apex Court, that is the Supreme Court. Now, I also urge the Commissioner of Police of the state and okay, the IG to instruct the commissioner of police of the state to make sure that the law and the decision of the apex court is being followed critically.
Across states? Or just Rivers State?
Rivers State and other states too, if their case is being...
Of caretaker.
Yes.
Right.
So caretaker should be erased in anything concerning the country. Everything that concerns the three arms of the government should be followed. And let me also sound it clearly that local government is the third tier of the government. Is the third tier of the government.
Yeah.
And as the third tier of the government is to be given due accord, due respect, due attention as the second tier. Also, yes.
Okay, what you're saying is that the third tier should enjoy the same level of independence that the federating units are enjoying.
Yeah, according to the constitution. According to the constitution.
All right, very well.
According to the constitution.
What do you have to say? You have been on this show, you have discussed this, but let me still get to hear your perspective.
Yeah, what I have to say in this regard is I want to salute the vision of the Honorable Speaker of Rivers State House of Assembly, Martin Samehule. I want to salute the courage of his brother legislators. I want to salute their interest in enhancing good governance and for repealing executive rascality. Because what we saw in Rivers State and other states, especially in my home state, Imo State, we are seeing executive rascality. And remember that the Supreme Court made mention of that the governors, have, resorted to using the name Solat. The Nigeria like a lot of phonetics and a lot of big names. Caretaker, they call it CTC chairman as an acronym. They have SOLAD, that's Solar Administrators. You have Transitional Committee. And the Supreme Court captured all those acronyms and said that if they are in nullity, they don't exist in the eyes of the law, and the Constitution of Nigeria is not known. And Martin Samehule, rules the curiosity of the Nigerian state. It was not in this dispensation that this case has gone to the Supreme Court, but it is also it will be recorded in the annals of history that from Rivers State, a certain speaker in the year 2024, because this law was made in February or March, has rewritten the history of Nigeria as someone who took the bull by the horn, took the executive by the jugular, and set the history right. Because those things have been in the Constitution, but who is talking about them? But he saw what other people have not seen. And thanks goodness, immediately he did it, and his brothers, it awoken the curiosity of the Nigerian state that the federal government have to go to the court, Supreme Court, to get this matter sorted out once and for all. Once and for all. But during Obasanjo era, it came. During Jonathan or Yaradua, some people went to court and said that the local government should be given their due autonomy. But we saw it didn't fly. But today, the Nigerian citizens who reside within the local government areas should be singing the praises and increasing. Nigerians like a lot of prayer, increasing their prayer points for a person of Martin Samehule, for his charismatic nature and for being a leader who came and saw what other people did not see. What did he see? He went to the Constitution and find out that there is a caveat that what is good for the good is also good for the gander. The Constitution of the Federal Republic of Nigeria, 135(3), captured how in any state of emergency or where election is impracticable, either by omission or commission, failed to conduct an election, that the tenure of the existing democratically elected office holder should be elongated by a 6 months period. But there is no war in Rivers State. There is no natural disaster like we are seeing in other countries, and the one that happened in Ukraine, where their president is still sitting. The elections should have been conducted since last year, but they are in war. The president is still sitting. Now in Rivers State, due to the inaptitude of the governor, his reasons best known to him, his action and inactions started when he did not capture the local government election in the purported budget he presented in December. You know, and now Martin Samuel, they looked at it and said, this governor is not ready to conduct this election. Therefore, the doctrine, not necessity now, but in the eyes of the law, is a doctrine of necessity. But when it comes into the one of Rivers State, is a doctrine of laissez-faire attitude, and they want to exhibit the executive rascality by the governor of Rivers State, and that the elections will not be conducted. Whatever his reasons are, then the legislature, being an independent arm of the government, went in search of how to curtail the excessiveness of the usage of executive power, went to amend the Rivers State Local Government Law number 5 of 2018. With due process of writing to the governor after passing it into bill, and that very day, Martin Samuel said that this will go down in the annals of history for the smooth running of the administrative office of the local government in Rivers State, so that there will not be a vacuum. And the Constitution captured it and said that the mandate of the people that their tenure will be elongated are still carrying the vote and the mandate of the people. It is not a one-person appointment, as we have seen in Rivers State. The governor of Rivers State had appointed caretaker executive chairman. So now they passed the bill and give it to the governor and waited. They waited for the governor to assent or not assent. They retrieved it and went through the legislative process again to reenact it after passing it in the form of veto. They vetoed the governor, and today that is where we are. And the Supreme Court has come to affirm it. And the Laurentia, before I leave it, because it's a whole lot of academic exercise, I want to say that I sat here on Thursday with a guest analyst, and he was saying that the Rivers State should not be beneficial to this, that the outgone local, he said the outgone local government channel will not be a beneficial to the Supreme Court. No! Martin Samuel, what the Rivers State House of Assembly have done is not, they did not wait for the, for the Supreme Court to come and do it. This is not a new constitution.
All right.
The Supreme Court drew their judgment from the constitution that is existing. Okay. And it is from the constitution that the Rivers State House of Assembly, heavily led by Martin Samuel, drew the action that they took. So we are in the letters of the law where the likes of Chidi Lloyd will not benefit in what the Supreme Court have done.
All right.
Is it a new constitution? Is it a new order? The answer is no. So what the local government, even the Supreme Court should have even awarded, told other states to pay money to the Rivers State House of Assembly for doing the needful.
That was not the prayer.
No, I mean, no, that is what they have done, you know, to lay credence to what they have done.
All right.
So what we are saying is that the local government chairmen are beneficiaries, because this is not a new constitution. It is a law that was rigorously passed. All and right. the Supreme Court and the government functionaries, the apparatus that are concerned, should enforce that particular law and make sure that those who are carrying the mandate of Rivers people return back to their seat until elections are conducted.
I'll still come back to that, but then
okay, let me just let's do things in this country the right way.
Okay.
You know, if something of this nature is happening in Rivers State, and IGP and maybe the commissioner police will say it's the politicians, the same thing will continue happening in other states. It is quite time that we have to put things straight. When a law is being made, and mostly in vetoring
executive powers.
It should be followed, because that means the governor, mostly in the state, that means the governor is not interested in that law. But that is the law that concerns the entire people. It's the law that concerns the entire people. What we say, they say democracy is the government of the people, by the people, and for the people. But as it stands now, some people see themselves, when it comes to you have been elected as a governor of the state, or you are the president of the country. The people, most people don't see that. It doesn't concern them. It's them. I'm the head. But they should look at it that whatsoever thing that is good for the gander is also good for the
goose.
You understand? So let us see the people that are supposed to enforce this law. Let them take the appropriate measures to make sure that this law is very followed. Yes. To ensure that our country starts getting a better name when it comes to democracy. Because if they allow Martins Amehule only and the 24, 27 members, they cannot.
They don't have the
power.
Yes.
But the only people that can enforce this power, as they know that it has been enacted by the Supreme Court.
Not even enacted, it's a constitutional issue.
It's in the Constitution.
It's a constitutional issue.
It's a decision also that has been reaffirmed by the Supreme Court.
Yes.
It has been reaffirmed by the Supreme Court, the Apex Court. The IGP should take it very, very serious.
All right.
And to make sure that this thing is very followed to the letter. And okay, let's come also to the amendment. The amendment should also be gazetted. I know too well that Martins will not wait to gazette it. So this particular ruling tomorrow should also be transferred to any state that wants to make the same mistake. That will also be correcting the aspect of the illegalities that is happening in our country.
All right.
Most of the states take it as is a normal thing. When it continues happening, does not mean it's a good thing. It doesn't mean that thing is the right thing. They should start correcting it now with this reaffirming of this law.
All right. Now, the question I want to ask is, now, both of you talked about it from the angle of the Rivers State House of Assembly, right? And I don't know if you are aware, but the matter, to a large extent, is in court.
I brought my state, Imo State.
Yes, it's in court. But now, apart from that, when you talk of enforcement, when the Supreme Court gave its judgment, they said it is to be implemented with immediate effect. Not just the local government tenure elongation, but also FAC allocation, and also with regards to the independence in the runnings and of the local government. Now, if the Supreme Court has said it is to be obeyed, the ruling is to be implemented with immediate effect, it boils down to the executive arm of government. Now, you recall that this matter is between the states and the federal. So the states were defendants in this case. And all their prayers and their suits were thrown out by the court.
Yes.
Now, if the Supreme Court said it is to be implemented with immediate effect, that order goes down to the executive government, because executive arm of government, because they are the ones that have been, going against the Constitution. You understand?
Sure.
So now, like we have talked about it, some states have quickly said, okay, we are going to have elections, so and so. And while that is still going on, FAC allocations, according to the Supreme Court judgment and order, has been stopped. It will not trickle down to the states with caretaker committees anymore. The question I want to ask is this: the governor of Rivers State not immediately implementing the order of Supreme Court, what is the implication of that? One. Now, the second question would be, if the governor does not implement this and the federal government ceases allocation due to the local government in Rivers State, how are these caretaker chairmen even running the states, their local government areas at this point? Is the governor funding them from monies meant for the states? Because right now, their funds comes directly from the federal government and not the states. So, is the governor going to fund them from the state's allocation instead of them receiving from federal? I don't know if my question makes sense.
Yes, it makes sense.
So now, let me start with you.
Okay.
No, let me start with you, Ugochukwu, very quickly. What do you have to say to these two questions?
When we talk about the enforcement, like Honorable Choche was saying, I still take it that my little wonder why the local government secretaries are still being manned by the Nigerian police, because given, if you draw it from the law that Martin Samehule has vetoed the governor, you will find out that their presence there is still valid very much, because that enforcement should be immediate, you know, because the Constitution, this is not a Supreme Court judgment per se. This is just Supreme Court, you know, reinforcing what the Supreme Court has said already. So we didn't need the Supreme Court to even come and tell us all this thing, because the Constitution captured it. So now, if you take it a little further, you find out that, like Honorable Churchill said, the governor has money. Maybe he has been using his private money, because this case now is not the case of Lagos State versus Olusegun Obasanjo during the Bola Ahmed Tinubu's time, because you know then Bola Ahmed Tinubu was trying to create LCDAs. Then the allocation was withheld. That elicited, enabled him to increase his IGR. Later, their monies were paid. So the federal government, I will blame them in this case, because you know that they went for a meeting. They went for their state and their federal meeting, and the federal government said, okay, we'll give you 3 months. You know, it's the federal government that is playing the mother figure here, you know, trying to have PTA, maybe especially because of the local government workers, because we don't know how they'll be paid. And given that more than 20 states are involved. So if you staff them or fund within this time, I hope federal government is giving them an ample opportunity to conduct elections. So that is what I'm seeing. It is not because they cannot enforce it immediately, but for the sake of those that are involved, that are not actors per se in what is going on.
All right, Honorable Churchill.
Okay, firstly, the question you asked first, if the governor refuses to do what is right, what is it like? To me, as a person, I know his negligence of duty. But in the other way around, he is also trying to let the River State people believe that he is the owner of River State.
How do you mean?
He is the owner of River State. That means nobody talks in River State. It's only him that talks. Because if the Supreme Court has given a judgment and you don't want to enforce it, that means you don't see anybody. And I would see it as he is attracting something dangerous on his own side. That means tomorrow, if they rise up to say they want to impeach him, nobody should start to
rise up.
the assembly now, because he's trying to truncate on. He's trying to.
You think it's an impeachable offense?
Gross misconduct.
It's a gross misconduct.
Negligence of
gross
misconduct.
So that one is one. Now, when we're talking about the enforcement, yes, he's the one that is supposed to enforce. If he is very, very wise, these issues that is happening in River State would have been curtailed by this time. After the ruling, what he would have done is give an open decision, this thing, and call everybody to come for inauguration. He inaugurates them and grant a press.
Start preparing for elections.
You understand that within this period, that the election is October, and everybody will sit up. But the funds, financial aspects, being sent to the executives that has been, their tenure has been elongated, is the right thing that the FAC is supposed to do. Because if they send it outside to that particular account and instructing that these are the persons that is supposed to sign it, of which we know. Accounts has not been changed. Signatories has not been changed because it's supposed to be changed in a normal process. So they should send it direct to that account and instruct.
Well, in this instance, you know, part of the Supreme Court judgment is that these states with caretaker chairman will not receive allocation.
There is no
caretaker when election is done.
Okay,
now. No, you cannot say there is no caretaker.
Elongation has already happened here.
Hold on. Rivers State still has caretaker committees as it is. Now, the question is, if the federal will no longer send allocations to local governments with CTC chairman, how is the Rivers State governor going to fund this CTC? Is it going to come from Rivers State pockets? If has said that, obviously it will come from the governor's personal
it has to come from his own personal pocket. In the sense that, as it stands, we all know, like I said there before this time, that the governor is not using the Rivers State money for now, the money from the allocation. So it can also come from his pocket, in the sense that as he's building his
he has appointed his friends and cronies.
Yes, as
caretaker.
So he can continue using his money from his post.
And let him not forget that the Constitution expressly stated that the three arms of government are independent: the judicature, executive, and the judiciary. And the legislature has firmly vetoed the governor, which they have the constitutional right to veto the governor. So it is already a law in Rivers State. By the act of what the Martin Samuel led assembly have done, it is a law that will not be raised by going to court or by doing any other thing. So it is left for the governor to do the needful. And in the case of Rivers State, their funds, even other states, if monies for other states will be sent to them, because there will be a window. Because let me use my state, Imo State, for example. The governor who opposed Odema have not conducted an election, so he's still with CTC or SOLAD or caretaker committee, as the case may be.
That means your state is included.
As the case, no, wait, I'm making a very good analogy here.
Very quickly.
See, if those states that have not hitherto conducted elections, there were no local government chairmen elected, seated, their funds will be restricted. The one for Rivers State, the governor has a window of receiving the allocation for the local government from the federal, because we already have executive chairman seated. Their tenure just expired.
No, their tenure has been extended.
No, elapsed. Their provisional 3 years has elapsed, and the extension we are done within the time they were still on seat.
The governor does not have that window because now they are not in the council.
No, but on the church will say if they are recalled,
have that, but have they been recalled?
No, that's what I'm trying to say. That the case of Rivers State is peculiar. That the governor has the opportunity to call them right the wrongs.
Yes. All right.
His own is very seamless. If he wants the local government to start receiving their own funds, he will just call them. A law has been existing law that is there for him to play with, and the state will move along. Within 3 months, he can now conduct an election as we know it in Nigeria and bring those his CTC, by writing those numbers to the RISEC to announce, and he will now bring them in as executive chairman, as the case may be in Rivers State.
Sadly, we are out of time. We would have loved to continue with this conversation, but this is where we have to wrap it up. Thank you so much, Honorable Churchy, for coming. It's always a pleasure having you.
My own pleasure.
Thank you.